appeal in the matter of Morais and others in Ryanair DAC.
Yes, Mr. Gott.
May it please your lordships and your ladyship, may it please the court. I appear on behalf of the appellant in this matter, Ryanair, together with my learned friend Joanne Claimants, King's Counsel. My learned friends Bruce Carr, King's Counsel, and Stuart Brittenden appear on behalf of the respondent claimants. My learned friends Daniel Stilts, King's Counsel, and Hannah Slarks appear on behalf of the interested party, the Secretary of State for Business and Trade. My Lords, this is an appeal from the London East Employment Tribunal and the decision of Judge Tobin made on the 4th of January 2021, which you will find for the note in tab 15 of the core bundle, pages 161 to 173, and from the Employment Appeals Tribunal in the order of His Honour Judge Auerbach made on the 18th of November 2021, core bundle, pages 134 to 135, and the learned judge's judgment of the 18th of November 2021 at core bundle pages 105 to 133. My lord, the court will see that the appeal has 3 grounds. I shall be dealing with each of those in turn, although there's inevitably some overlap between ground 1 and ground 2 when we come to the material relied upon by the parties. Ms. Clement will follow dealing with the respondent's notice and the human rights elements relating to appeal grounds 1 and 2.
Now, before you go into the grounds of appeal, let alone the respondent's notice, it strikes all of us that the judgments and the skeletons rather assume familiarity with the earlier parts of the story. I recall that some aspects of the case have been settled following the Mercer decision. It would be helpful to us if, not assuming any previous knowledge, you showed us what Mr. Morais and his colleagues' original claims were, what has been settled and what is still in dispute.
My lord, yes. If we go to the core bundle, and the grounds of complaint are found at begin at pages 201. That's the ET1 with the grounds of complaint at pages starting at page 215. And you'll see, and this is a factual background I was going to take the court through in any event, but paragraph 4, the claimants each bring proceedings pursuant to section 146, 1B, and or 1BA of the Trade Union and Labour Relations Consolidation Act 1992, the 1992 Act. That part of the case has been dismissed pursuant to your lordship's order. The case under paragraph 4.2, relying upon the regulations 3 and 9 of the Employment Relations Act 1999, Blacklist Regulations, we call them the Blacklist Blacklist Regs. That is the extant part of the case. So the matter began on the same facts, that is the removal of concessionary travel privileges as a result of participation in industrial action on the 18th and 19th of September 2019. Began on those same facts as a Section 146 claim and a blacklisting claim. But has now been reduced down to the blacklisting element alone.
Yes.
Could I
My lord.
just understand what that means in practical terms? The claim under Section 146, had it succeeded, would have focused upon financial compensation for the withdrawal of the benefit. Is that what that claim amounted to in real terms?
Yes, my lord.
Right. And so that died a death consequent on Mercer.
My lord, yes.
Can you, we can look it up if necessary, can you just link in what you're telling us with the order that my lord made disposing of that aspect of the matter, whereby ground 1 was dismissed and grounds 2 and 3 allowed? What was going on with that order, which we find in the supplemental bundle at 161?
Excuse me.
Well, the order is the dismissal of ground ground 1 of the appeal, but the
So what was ground 1 of appeal? Is that what we've been talking about?
page 74 of the supplemental bundle, my lord. And there's an element of confusion about this, an understandable confusion, I should say, because there were 2 parallel appeals as a result, as a result of the way in which the matter went through the EAT. But ground 1 of the what I described as the Section 146 appeal was dismissed. Ground 2 of the 146 appeal, that's over on 75, my lord, page 75, was allowed, and ground 3, perversity and failure to provide adequate reasons, was allowed by way of my Lord Justice Bean's order of the 7th of May 2024. So that was the end of Section 146 for the purposes of these proceedings and this appeal. And paragraph 4 of my Lord Justice Bean's order on the second page, page 162 of the bundle, also dismisses the Section 146 claims.
And so far as the claimants are concerned, that particular claim for compensation has failed, and the only consolation they have is the declaration of incompatibility that was made in the Supreme Court.
Well, the declaration of incompatibility made in the Supreme Court was in respect of Mercer. They have
Are we not under the same, were they not travelling the same path?
Well, they were in parallel. For the purposes of this court, we were in a holding pattern behind Mercer,
Yes.
because it was thought, and quite rightly, that Mercer could resolve some or all of the issues. And indeed, my submission to this court this morning is that, in fact, it has resolved all the
Well,
issues.
you agreed it resolved some of the issues, which is what led to the order that my lord made, which we're just catching up with. But when I put to you a moment ago that I just want to make sure that I'm not pointing in completely the wrong direction before we get into the substance of this, that in effect the consequence of the Supreme Court decision in Mercer is that Mr. Morais and his colleagues' claims have failed insofar as they proceeded under 4.1, section 146. And when I put it in this way, that the only consolation that they might feel as a result is that they've been told your claim has failed, but the law is not compatible with the Human Rights Act.
They have that consolation. Yes, my lord. I was
Right.
I was,
Okay. So I've not misunderstood that. So then could you, before I get out of your road, explain to me what the consequence, what rides on this appeal in relation to the blacklisting regulations? What is, if you'd like to take us back to the original claim, how do you like to explain it? If 4.1 goes nowhere any longer, what are the consequences of the argument that you're having about 4.2 and the blacklisting regulations?
well, the consequences, the claimants, Mr. Morais and his colleagues, rely on exactly the same facts for 146 and for the
Yes.
the blacklisting regulations. The compensation provisions within the blacklisting regulations are different to section 146, but they are looking for compensation which shall not be less than £5,000, which is the blacklisting provision. Alternatively, damages for injury to feelings under section 149, which has gone, damages for pecuniary losses occurring as a consequence of the withdrawal of the benefit of discretionary travel privileges under regulation 11.3.
Right, so there is a potential financial gain to the claimants under the decisions below. Is it, you said it's different, but is the sort of compensation that you get for a breach of the blacklisting regulations, which I've never come across, is it comparable to what the compensation would be if there had been a breach of section 146?
Well,
Is it the same fight, but just fought under a different part of the legislation?
well, my lord, if I could take you to, I think it's in bundle 1 of the authority bundle.
Would it help if you told me the answer and then showed me why you're right?
My lord, if that assists,
Yes.
I will do. But the remedies under regulation 9 are an award of compensation that shall not be less than £5,000. And where the tribunal finds that an act or failure complained of was to any extent, so that's the contributory clause, and the there's then a provision under 11.8 to prevent compensation being claimed under, prevent double recovery under section 149 and the blacklisting regulations. So and there's also a provision for the claiming of any expenses and loss of benefits. So there is no, as it were, general injury to feelings claim, but the compensation is set at a minimum of £5,000.
Could you kindly give the page reference again?
It's page 171 in the authority bundle behind tab 8. Sorry, behind tab 7.
Well, the case is still on preliminary issue. The remedy has not been tried.
The remedy's not been tried.
Right, thank you.
Thank you very much.
Right.
Ground one of this appeal, my lord, is that the Employment Tribunal erred in concluding that the term activities of trade unions in Regulation 3.2a of the Blacklisting Regs includes participation in industrial action, and the EAT erred in failing to correct that error. If this court finds in our favour in respect of ground one, that's the end of the matter, subject to any points in the respondent's notice, and grounds 2 and 3 fall away. Ground 2 concerns the outcome of the claimant's cross appeal before the EAT. The Employment Tribunal correctly concluded that if participation in industrial action falls within Regulation 2.3a, and it is our position that this court should not find that that's the case. But if participation in industrial action falls within Regulation 3.2a of the Blacklisting Regs, only industrial action which is both legal and official falls within these provisions. That was the employment judge's finding. The EAT erred in departing from that conclusion and afforded protection to all those taking part in union industrial action, which is a novel, undefined and uncertain concept. His Honour Judge Auerbach, my lord, wasn't satisfied with protected industrial action being the industrial action under Regulation 3.2a. He wasn't satisfied with official industrial action in the section 20 authorised or endorsed sense. He created a sui generis concept of union industrial action, which is novel, undefined and an uncertain concept. And indeed it's a feature of this appeal that nobody seeks, by way of skeleton argument, to defend the position taken by His Honour Judge Auerbach in coming up with this this notion. Our position ground 2 is that if industrial action is covered by Regulation 3.2a, it has to be protected industrial action. Legal, official, protected industrial action. The position of the claimant respondents and the Secretary of State is that such industrial action only has to be official. So it only has to be endorsed, authorised or endorsed in accordance with Section 20 of the 1992 Act. The third ground of appeal is that the Employment Tribunal erred in concluding that it would be an abusive process for Ryanair to argue that the industrial action taken by the claimants was not protected industrial action, and the EAT erred in failing to correct this error. So part of my client's response to the claim of the claimants is that firstly, that the Regulation 3.2a does not cover any industrial action at all, but if it does, it only covers protected industrial action. It was held by the tribunal and upheld by the EAT that it was an abusive process for my client to adopt that position. As regards the respondent's notice, the respondents adopt the reasoning of the EAT, but in the alternative assert that the conclusion was correct by reference to the interpretative obligation under Section 3 of the Human Rights Act, 1998. And they have a second ground in the respondent's notice.
Can we just look at the respondent's notice?
Yes, it's at page 46 of the core bundle, my lord.
Yes.
My lord, perhaps I should deal with some factual background. The claimants, as you
There wasn't much.
Sorry?
I said I thought there wasn't much.
No, there isn't much, my lord. So I'll try and take it at pace. The claimants are all pilots employed by my client Ryanair, which provides concessionary travel privileges to its pilots, which can include reduced rate travel and free travel. And my lord, if we go to page 15 of the supplemental bundle. My Lord, do you have a section of a contract with clause 16.1 concessionary travel?
Yes.
My Lord, this is a standard form contract for pilots at Ryanair, and clause 16.1 allows, on joining Ryanair, you may avail of privileged travel concessions at sector rates on a subload basis. Subload means you're on a waiting list, no confirmed seats. On Ryanair scheduled flights, after 12 months service, you may qualify for further travel with Ryanair and other nominated carriers who have an interline agreement with Ryanair. All reduced rate or free travel is a concession only and is not an entitlement to Ryanair employees. This concession may be amended or withdrawn at any time at the direction of the airline. Details of these concession benefits are contained in the rough guide to Ryanair. So that's the concession. In August of 2019, BALPA, the trade union of the claimants, notified Ryanair of intended dates of strike action, which dates included the 18th and 19th of September 2019. On the 16th of August, Ryanair issued a claim form against BALPA, seeking an injunction to prevent BALPA from calling that strike. And that is in the supplemental bundle, pages 48 to 51. My Lord, the attachment to the claim form, I think it's been christened as the particulars of claim, but it isn't the particulars of claim, is at page 50 and seeks the relief against BALPA in fairly standard form, seeking to prevent BALPA from inducing breaches of its members' contracts by taking industrial action which is not protected pursuant to section 219 of the 1992 Act. And that, my Lord, is as far as the pleading went. A claim form was issued, and an injunction application made, which was heard before Mrs. Justice Lambert. Now, my Lord, as the court will be aware, injunction applications in respect of industrial action usually concern defects in the balloting process, the ballot notice, or notices of intention to call, or the notices of intention to call industrial action. They, and this one was no exception. Typically, if an injunction in respect of industrial action succeeds, the trade union will go back and seek to remedy the defect in the ballot process or the notice of industrial action, and or the parties will seek to resolve the trade dispute by industrial means. If the injunction fails, the proceedings will typically be discontinued, and the parties will seek to resolve the issue by industrial means. The actions in respect of the substantive actions in respect of injunctions for seeking to prevent industrial action rarely, if ever, actually go to trial. And I think that's a matter classically recognised by Lord Diplock in Cambridge and Woods. No purpose is served by progressing the proceedings, as by the time the matter comes to trial, the dispute will invariably, for industrial relation purposes, be ancient history. The employer and the trade union will have moved on into a harmonious period of operation, or perhaps more typically will have moved on to other and fresher disputes, but actually arguing out at trial the issues which gave rise to the injunction application is rarely, if ever, done, because it serves normally no real purpose and is not conducive to good industrial relations. The injunction, my lord, is a flash in the pan, whereas extended proceedings are a full pan, a chip pan fire. Now, the interlocutory application was heard by Mrs. Justice Lambert on the 21st of August 2019, and that is in her decision is in the authority bundle at tab 24, which is the second authority bundle. And my lord, she determined Mrs. Justice Lambert determined the matter as is required pursuant to section 221 of the Trade Union and Labour Relations Act, which is something I will take the court to. I'll be cantering through the 1992 Act as part of my of this opening. But at paragraph 9 of the judgment, Mrs. Justice Lambert says this: it's common ground that an interim injunction to prevent a strike going ahead is normally decided on the merits of the claim, and that under section 221 of the Act, the court should have regard to the likelihood of the union establishing the section 219 defence at trial. Section 219 defence is, and again I'll be coming to this, section 219 defence is the statutory immunity granted to trade unions, provided that they have complied with the balloting and notice requirements within Part 5 of the 1992 Act. It follows that the court does not apply the normal American cyanamide test. Rather, the court is required to assess the strength of the union's defence to the claim for the economic tort. If it is more likely than not that the union will succeed in establishing the defence at a full trial, it is only in a very exceptional case that an injunction should be granted. And then overleaf, paragraph 32 is the ultimate conclusion of Mrs. Justice Lambert. I'm satisfied that the section 219 defence is likely to succeed, notwithstanding Mr. Gott's skillful presentation of the arguments. I find that his allegations of technical breaches of the legislation are not made out. Given that conclusion, I see no basis for my granting of an application for an interim injunction. I dismiss the application. My lord, my client, for the purposes of that injunction, had 4 points. They all fell flat. and the application failed, and the proceedings were dismissed by agreement, and that's page 58 of the supplemental bundle. And you'll see the claimant's application having been dismissed, the claimant is to pay the defendant's costs summarily assessed in the sum of 88,120 odd, and then the claimant's claim is discontinued with no further order for costs. My signature and somebody signing on behalf of Andrew Burns QC. And that, my lord, is the standard pattern for a failed injunction application by an employer. And I'll come, I'll deal with this when I come to ground 3 in the abuse of process point. Now, in respect of the strikes of the 18th and 19th of September 2019, a memorandum was sent by Darrell Hughes, who is Ryanair's Director of Human Resources, to Ryanair pilots. It's at page 31 of the supplemental bundle. Dated the 16th of September, and picking it up at the third paragraph, Balper's attempts to damage our business are ill-timed given the threat of no-deal Brexit, the MAX aircraft delays, and the environment of lower fees and lower costs which have been hitting a string of airline bankruptcies, sales and restructurings, including just this week, Aigle Azur in France going bust and Norwegian seeking another rescue from the bondholders. As you are aware, Ryanair will be forced to close or cut bases, including Belfast, Leeds, Bradford, East Midlands and Stansted. This is a time when Balper should be working with Ryanair to minimise job losses, instead of calling further pointless strikes and refusing our repeated requests to progress negotiations. As you know, staff travel is a discretionary benefit, allowing generous discounted access to Ryanair flights, including confirmed flights with new blue tickets. Ryanair is not prepared to extend this discretionary benefit to the tiny number of UK pilots, less than 5%, who continue to support these failed strikes just to damage our bookings, our business and your job security. Accordingly, any UK-based pilot who engages in any further Balper strikes in September will have their travel privileges removed for 12 months. We hope that this will not be necessary because everyone will work their rosters as normal. So that's the opening salvo from Mr. Hughes. And then base supervisors, let's say those at airports, provided details of those who did not attend for their rostered duties on the 18th and 19th of September. So at the airports, information was collated in respect of those who didn't turn up. Ryanair compiles spreadsheets to record those who did not attend for rostered work on the 18th and 19th of September, and the pilots' rosters were updated accordingly on what's called Ryanair's netline rostering system. On the 18th and 19th of September, Ryanair's head of flight operations ran a report in Dublin which produced a list of pilots who had not attended for their rostered shifts on the 18th and 19th of September. Mr. Rogers sent this to Interline Dublin, who manage staff travel benefits, and Interline Dublin removed each pilot's access to the discretionary travel booking system. Mr. Rogers produced a short witness statement dealing with this, which is to be found for your Lordship's note at page 199 of the core bundle. On the 19th of September, Mr. Rogers wrote to the UK pilots who did not attend for rostered duties on the 18th and 19th of September, and informed them that their discretionary staff privileges were being withdrawn. And my lord, that's page 45 of the supplemental bundle.
What is set out in the ET1 as the narrative of what happened is not disputed at all, is it? Of course, the legal labels to be put on it are disputed.
Well, the precise detail of the creation and the making of the lists is a matter of, remains a matter of dispute. But yes, your Lordship is correct as regards the correspondence. The letter of Mr. Hughes and then the subsequent letter of Mr. Rogers. No, that's not disputed. But if your Lordship has the grounds of complaint open, the page 218. You can see the wording of Mr. Hughes' letter, the wording at paragraph 16, the wording of Mr. Rogers' letter at paragraph 18, and then overleaf at paragraph 20. So, paragraph 17, in the premises, this is in respect of Mr. Hughes' letter, in the premises the respondent issued a clear and unambiguous threat to each of the claimants, warning them that if they participated in official and lawful industrial action, then they will be penalised with sanctions being imposed in relation to the continued provision of travel benefits. Accordingly, the purpose of the 16 September 2019 correspondence was to deter or dissuade the claimants and other union members from participating in lawful industrial action, described by the respondent as the Balfour strikes. And then overleaf at paragraph 19, purpose of the 19 September correspondence, that's Mr. Rogers' letter, was to penalise the claimants as members of an independent trade union who had chosen to participate in lawful industrial action. Now, my lord, some statutory material.
Yes.
My Lord, I'm sorry to interrupt at this moment. I just want to make sure that the court's not misled in relation to your observation that the facts within the claim form were not in dispute. It's now not in dispute that a list was prepared and that list was used. But if you look at paragraph 24 of the ET3 on page 189, you'll see the initial position taken by Ryanair was simply that they had changed a toggle, and therefore paragraph 21 of our claim, which is where we asserted that they must have produced a list, was denied. So that was initially an issue. That's rather fallen away as a result of disclosure and further witness statements provided by the respondent. But certainly at the initial stage, there was a dispute as to the material facts and that key issue as to whether or not a list had been prepared.
My lord, perhaps I could start with the 1992 Act. Which is behind tab 3 in Authority Bundle 1. Now, the court may be aware that the 1992 Act has been something of a political football and has been amended by successive administrations since it came into effect in 1992, and with the introduction of the Employment Relations Bill 2024, which has been included in the bundle of authorities, it looks like that game is still on. Just taking page 15 behind tab 3, the quasi-corporate status of trade unions to be relevant to ground 3 of the appeal. A trade union is not a body corporate, but it is capable of making contracts, capable of suing or being sued in its own name, whether in proceedings relating to property or founded upon contract or tort or any other course of action, proceedings for any offence alleged to have been committed by it or on its behalf. So that's the status, as it were, of a trade union. Page 17 is section 20 of the 1992 Act. And this is mainly going to be relevant to ground 2, but section 20 establishes the liability of trade unions for certain proceedings in tort. And section 20 sub 2 sets out the acts which are to be regarded as authorised or endorsed by a trade union, and those who may authorise or endorse the acts of a trade union. And 2A, person empowered by the rules, that's the rules of the union to do so. B, the principal executive committee or the president or the general secretary. Or C, by any other committee of the union or any other official of the union, whether employed by it or not. So there are three pathways to authorise or endorse, and official industrial action for the purposes of the 1992 Act has to be authorised or endorsed by the trade union by one of those three pathways. For the purposes of the third pathway, Section 20 sub 2c, the trade union can repudiate and the act of the trade union official, and it does so by going through a fairly convoluted process: written notice of repudiation, written notice provided to the employer and to those who are, and to every member who it has reason to believe might otherwise be taking part in industrial action. Section 22, for completeness, is the limit on damages which can be awarded against trade unions depending on their size. BALPA falls into row 2, 5,000 to £25,000, so a maximum damages of 200,000. Moving then to the sections which are to be found under Part 3 of the 1992 Act. Part 3 is christened, in the Act itself, Rights in relation to union membership and activities. We have at page 25 section 146. And this section 146, which was considered at length and repeatedly in the proceedings in Mercer from the Employment Tribunal to the Supreme Court, a worker has the right not to be subjected to any detriment as an individual by any act or any deliberate failure to act by his employer, if the act or failure takes place for the sole or main purpose of preventing or deterring him from being able to, seeking to become a member of an independent trade union, or penalising him for so doing so, preventing or deterring him from taking part in the activities of an independent trade union at an appropriate time, or penalising him. Now, my Lord, it is section 146 1b, which detained the courts in Mercer. My learned friends in their skeletons make much of the words "at an appropriate time," which are defined in subsection 2, in an attempt to outflank the Supreme Court in Mercer. But that, for reasons I'll come to in due course, is a hopeless manoeuvre. Section 149 is the, upon page 28, are the remedies available for a breach of section 146. And section 152 is on page 30 is the provision corresponding with section 146 dealing with dismissals on grounds related to union membership or activities. So for the purposes of Part 10 of the Employment Rights Act 1996, Part 10 of the Act deals with the 96 Act. Is a section dealing with unfair dismissal. Dismissal of an employee shall be regarded as unfair if the reason for it, or the principal reason for it, was that the employee had taken part or proposed to take part in the activities of an independent tribunal, independent trade union at an appropriate time. So, in Mercer, Lady Simler describes Section 146 and Section 152 as sibling provisions, and they essentially mirror one another. Now, Section 219. Section 219, my Lord, brings us into Part 5 of the 1992 Act, which deals with industrial action. And Section 219 is the golden formula classic statement of the statutory immunity from liability for the economic torts of inducing breach of contract. However, that is subject to removal from a trade union if it fails to conduct a ballot, and the requirement for the ballot is at Section 226 on page 52. The requirement for a ballot notice is at page 55. And I'm taking this, dealing with this because it's likely to be relevant when the court comes to consider the issue of RMT in the UK on the respondent's notice. I'm just, as it were, doing a whistle-stop tour of the 1992 Act. Notice, so the trade union has to serve a notice of ballot in the form specified in section 226A. Thereafter, a ballot occurs in which page 61, entitlement to vote in the ballot must be accorded to equally to all members and no others. There are then, my Lord, 228A on page 62 and 63, some relatively difficult provisions on separate workplace ballots and aggregate ballots. The voting paper and the form of the voting paper, section 229, page 65. The conduct of the ballot, section 230, page 67. The ballot is a postal ballot, but that is likely to be changed by the forthcoming legislation. Section 231, 69. Information as to the result of the ballot to be provided to members. Overleaf section 231A. information as to the result of the ballot to be provided to employers. A scrutineer's report, section 231B. Section 232B, balloting of overseas members. I think we can leave that aside. The period after which the ballot ceases to be effective, 78, which is a period of, in essence, of 6 months. So section 234. Notice, section 234A, notice to employers of industrial action, and essentially an employer has to, a trade union has to provide an employer with 14 days notice of its intention to call industrial action. And the section 236. Section 236, no compulsion to work. Again, it's relevant to ground 3, but the court has no power to require anybody to work. So individuals and individual employees are never defendants to injunction applications in respect of threatened strike action. Dismissal of those taking part in industrial action is at 237, and this is an important part of our case for this appeal. Dismissal for section 237 is dismissal for those taking part in unofficial industrial action. That is to say, industrial action which has no, it's not authorised or endorsed by the trade union pursuant to section 20, which I took the court to earlier. Dismissal in respect of official industrial action the position in respect, which is dealt with under section 238, a not straightforward set of provisions, but which boil down to there's no right to claim unfair dismissal unless dismissals of others have been selective or there has been selective re-engagement. And section 238A is participation in participation in protected industrial action. The title is oddly misleading, but the section 238A sub 1 defines protected industrial action, and it is industrial action which a person takes when the trade union calling it has the protection of section 219 of the 1992 Act. And again, it boils down, 238A boils down to a dismissal for participating in protected industrial action will be automatically unfair unless the employee is still taking strike action after the expiry of 12 weeks. And lastly, for the 1992 Act, page 114, section 239. Section 239, sub 1, sections 237 to 238A, that is the three sections dealing with dismissal in respect of industrial action, shall be construed as one with Part 10 of the Employment Rights Act. My Lord, that is an important provision because, of course, in the same way that Section 152 of the 1992 Act could not be accommodated within the regime of Section 237 to 238A in Mercer. So Section 104F, which I will come to in due course, dealing with dismissal for a reason relating to a blacklist, cannot be accommodated within the regime of Section 237 to 238A. And Section 237 to 238A, in accordance with Section 239, are to be construed as one with Part 10 of the Employment Rights Act 1996.
You may have to explain that more slowly. I had read 2391 as saying you have just had 3 sections about loss of unfair dismissal protection. What is unfair dismissal? Go to Part 10 of the Employment Rights Act 1996 and you will find out. But you say it's more significant than that.
Well, I'm saying that it needs. I'm saying that the Section 237 to 238A have to be read consistently with Part 10 of the Employment Rights Act 1996, because they have to be read as one. And it's a submission I'll develop, but in the same way that Section 152 in Mercer could not be accommodated within the regime for dismissal in respect of industrial action in Section 237 to 238A. There is Section 104F that likewise can't be accommodated that regime.
Should we just look at that?
My Lord, yes, it's page 125.
this is a species of automatic unfair dismissal.
My lord, yes. It's a species of automatic unfair dismissal where the dismissal relates to a prohibited list.
Yes.
And if regulation 2.3a of the 1992 Act encompasses industrial action, if regulation 2.3a of the Blacklisting 3.2a of the Blacklisting Regs encompasses industrial action, then we have exactly the same conflict in respect of 146 and 152 in Mercer following Drew, and we have exactly the same problem. We have section 3.2a Blacklisting Regulations containing industrial action. A dismissal relating to a prohibited list arising from that, and then section 104F making such a dismissal automatically unfair. For example, my lord, imagine somebody who was taking protected industrial action, who was still taking protected industrial action after 12 weeks. That person could be dismissed under section 238A. Would be automatically unfairly dismissed under section 104F. Now, my lord, as I say, I'll develop that submission. We're still in the introductory stages of the legislation. If I could perhaps then move to the 1999 Act. Page 127 of the authority bundle. Well, this is the 1999 Act is the enabling legislation for the Blacklisting Regulations. Sections 3.1a and b provide the authority to make the blacklisting regulations. Secretary of State may make regulations providing the compilation of lists which A, contain details of members of trade unions or persons who have taken part in activities of trade unions. So that mirrors the word in the in the later blacklisting regulation are compiled with a view to being used by employers or employment agencies for the purposes of discrimination in relation to recruitment or in relation to the treatment of workers. And then overleaf sub 6, subject to subsection 5, expressions used in this section and in the Trade Union and Labour Relations Consolidation Act 1992 have the same meaning in this section as in that act. And that is something that provision maintains the consistency between the 1992 Act and the 1999 Act. Now, section 16 at page 129, not a particularly exciting statutory provision. Schedule 5 will have effect. But if we then go, my lord, to Schedule 5, Schedule 5, page 138, Schedule 5, my lord, is where section 238A of the 1992 Act comes from. Section 238A on dismissal for taking protected industrial action was inserted into the 1992 Act by the Employment Relations Act 1999, the same piece of legislation which was the enacting legislation, enabling the legislation for blacklisting. And again, it's another reason why within the statutory network, consistency is maintained between the 1992 Act, and the 1999 Act and the regulations subsequently issued under it. And Schedule 2 of the of the 1999 Act makes a number of further, picking it up page 131, makes a number of further amendments to the 1992 Act. Now, enabled by the 1999 Act are the Blacklist Regs, which are at behind tab 7 at page 1, beginning at page 163. page 165, we have the general prohibition. Prohibited list is a list which contains details of persons who are or have been members of trade unions, or persons who are taking part or have taken part in the activities of trade unions, and is compiled with a view to being used by employers or employment agencies for the purposes of discrimination in relation to recruitment.
Keep your voice up, Mr. God.
Sorry.
Talking into your notes a bit.
It's all on live stream as well. Or in relation to the treatment of workers. So there, that directly mirrors the wording which I took your lordship to in the 1999 Act. Regulation 9 is then the detriment. Person P has a right of complaint to an employment tribunal against P's employer, D, if D, by any act or any deliberate failure to act, subjects P to a detriment for a reason which relates to a prohibited list. And Regulation 12 Part 10 of the Employment Rights Act 1996 is amended as follows, and here we are again, Section 104F, blacklists, and that is the provision which I took you, Your Lordship, to a moment ago, dealing with dismissals for a reason relating to a list, prohibited list.
Could we look at the regulations around and following Regulation 3 just to understand what the structure of the instrument is? Well, so 3 starts with a general prohibition on compiling, using, selling or supplying a prohibited list, which is then defined.
There are a series of exceptions to the general prohibition, revolving around those with a legal duty, a requirement, those who are required or authorised to make lists by any enactment or any rule of law. And then there are provisions dealing with refusal of employment or employment agency services as a result of blacklisting. That's Regulations 5 and Regulation 6. And then remedies in respect of refusal for employment or refusal for...
The main one, maybe for our purposes, 4, is it? Just to see what was intended not to be a prohibited list.
The general prohibition is that in Regulation 3 is then subject to the clawbacks, the exceptions to the general prohibition to be found in Regulation 4. And
But the main, as it were, carve-out is contained in the definition of a prohibited list, so that, for example, let's suppose your client had simply wanted to create a list so that everybody would know to update the rosters. Then clearly that would not engage 3.2b.
My Lord, no, it would not. I mean, there are multiple legitimate reasons why during the industrial action an employer might wish to draw up a list of those who were not attending.
Yes.
Health and safety in the building, to know who was actually there, update the rosters, and in industrial action there will always be a list because you have to know who not to pay. So there will not paying those who participated in industrial action is not regarded as a detriment for the purposes.
Yes.
No work, no pay is
No, but
universally understood.
Removing fringe benefits.
Removing fringe benefits
is different.
It's something which is directly addressed in Mercer, and I will come to that.
But in the present case, the sequence of events was suggested. I just want to know whether there's an issue about this or not. That the purpose of drawing up the list in this case was to make sure that the toggle was then toggled in relation to access to benefits. I mean, the chronology is not we need to have a list because we need to make sure our rosters are correct. The chronology would appear on the face of it. I just ask for your comment to engage B.
Well, a number of lists were drawn up, and the initial lists were drawn up to at the bases by base managers, i.e. those in charge of Ryanair at individual airports, making a list of those who hadn't turned up. And then that material was made into spreadsheet, a spreadsheet, and those spreadsheets were placed on the Ryanair netline system. But our position, my Lord, in respect of the in respect of the list is set out in the further and better particulars, backed up by the statement of Mr. Rogers.
I don't want to take you out of your course because you may be wanting to get to this at a more appropriate time, but is it possible to answer whether the issue in this case and now on the appeal concerns 3.2a, namely the issue of taking part in the activities of trade unions, or did you also have an argument in relation to 3.2b?
Well, for the purposes of this appeal, it's 2.3a.
Right. Okay, so we don't have to trouble with B. We can take that as being part of the context and take it as read.
My Lord, yes.
That's helpful. Thank you.
Lord, it may be slightly different from that. You can proceed on the basis that B is satisfied, that it was prepared for the purposes of subjecting my clients to a detriment. To go slightly further than perhaps your Lordship indicated.
Well, that matter, that issue has yet to be determined. It wasn't one of the preliminary issues.
Just to flag this up, my lord, the Secretary of State will say that the limitation contained in 3.2b is important in rebutting some of the arguments put forward by my learned friend in his supplemental skeleton argument. So it is relevant in that sense, even if not an issue, just to be clear.
Well, we'll come to this in due course. One thing which would be appalling is if after all these years, if the appeal were to be dismissed, there were then to be more preliminary issues, taking a few more years before the case gets to trial. We'll come to that. Right, Mr. Gott, are we done with statutes?
My lord, we are. Mercer.
Yes.
Tab 30, Second Authority Bundle, 717. My lord, the Mercer and the Supreme Court, after a lengthy passage, the claimant was a care worker and trade union representative and was employed by the respondent charity. She was disciplined for organising and participating in industrial action. The preliminary hearing in the Manchester Employment Tribunal, the tribunal found that as a matter of ordinary language, participation in industrial action as a trade union representative might be regarded as part of the activities of a union, but that in the light of the domestic authorities, the proper interpretation of Section 146 was that industrial action was outside the scope of the section. The tribunal, or finding that the improvement.
We have read the head note, Mr. Gott.
That's kind, I'm sorry. In which case, could I take the court to paragraph 44. Paragraph 44, Lady Simler is looking at the domestic constructions of Section 146 of the 1992 Act. And said this, like the courts below, I consider that read in isolation and as a matter of ordinary language, the phrase activities of an independent trade union in Section 146 is apt to include participation in or the organisation of lawful strike action. However, the phrase cannot be read in isolation. And then there's the authority of Drew and Edsonbury Borough Council, which deals with the precursors of what are now Section 146 and 152. And my lord, you'll see that the domestic interpretation of Drew was not contested. Neither side, in this case, has suggested that the analysis in Drew is wrong as a matter of domestic law. And there, the Supreme Court uphold the finding of Justice Slynn, as he was, in Drew, in the EAT, where he held, but the tribunal considered that there was a distinction between the activities of an independent trade union and taking part in other industrial action. It was their view that if what happened was taking part in industrial action, then it would not be a trade union activity for the purposes of Section 58 of the Act. The predecessor of Section 152, whatever might be the position as a matter of ordinary language, under Section 58, an employer dismisses because a man has taken part in activities of an independent trade union, then the dismissal is unfair. Under Section 62, if an employee takes part in a strike or other industrial action, the position is entirely different. There, a man is not entitled to the claim that he has been unfairly dismissed, when at the date of the dismissal he was taking part in a strike or other industrial action, unless he can show that the other employees who, to put it broadly, were taking part in the industrial action were not dismissed. So that's the selective dismissal element in what is now Section 238. And then it is quite impossible for the same person to fall under both those sections. Accordingly, it seems quite clear that there was intended by Parliament to be a distinction for the purposes of a claim of unfair dismissal between what is an activity of an independent trade union and taking part in industrial action. It seems to us that that distinction is borne out for the purposes of the legislation when one considers the terms of Sections 23 and Section 2381 of the Act, which are dealing with trade union membership and activities and time off for trade union activities.
That was either the 1974 or 1975 Acts, wasn't it?
I think the 74, my lord.
74. Did the relevant section have the phrase "at an appropriate time"?
Yes.
Yes. Thank you.
And then Lady Simler goes on in paragraph 45 to note that the analysis of Drew is supported by at an appropriate time. And then in paragraph 46, this conclusion is reinforced by considering the wider scheme of TULRCA and the limited protection available to individuals who participate in lawful industrial action. In Part 5, that's sections 237 to 238A. This detailed scheme allows an employer lawfully to dismiss an employee for participating in industrial action where the action is unofficial, or dismissal is not selective unless Section 238A applies, or the employer waits for a period of 12 weeks after the commencement of the industrial action. There is accordingly no universal protection provided to workers against dismissal or participating in industrial action, although plainly the conditions in which such a dismissal is lawful are limited. By contrast, separate protection against dismissal for participating in activities of a trade union at an appropriate time. The parallel provision to section 146 is contained in section 152 of TULRCA. To construe section 152 as including lawful industrial action in working hours would mean that an employee dismissed for engaging in industrial action at an appropriate time could bring a claim for unfair dismissal under section 152 and thereby avoid the carefully constructed regime giving limited protection to dismissals under section 237 and 238A. For the reasons given in Drew, that cannot be right. An employee dismissed for taking part in industrial action cannot fall within both section 152 and sections 237 to 238A of TULRCA at the same time. Otherwise, the employee would be entitled to a finding of automatic unfair dismissal under the former provision, but would be subject to a limited protection against unfair dismissal under the latter. And the regime in sections 237 to 238A would be redundant. Now, my lords, the position of my client is that one can take that passage from Lady Simler's judgment and for the reasons given in and insert section 104F of the Employment Rights Act. So, for the reasons given in Drew, that cannot be right. An employee dismissed for taking part in industrial action cannot fall within section 104F and sections 237 to 238A of TULRCA at the same time. And that is what will occur if industrial action is included within the meaning of activities of trade unions within regulation 32A of the Blacklisting Regs.
I'll say that again. An employee blacklisted, not dismissed.
No, an employee who is dismissed for a reason relating to a prohibited list. Section 104F deals exclusively with dismissal.
I may have written it down wrong. Just say it again, Mr. Goff.
For the reasons given in Drew, that cannot be right. An employee dismissed for taking part in industrial action cannot fall within both section 104F and sections 237 to 238A of TULRCA at the same time. My Lord, actually, no, if we could turn to the Employment Relations Bill 2024, which is Parliament's response to Mercer.
Sorry, this is Parliament's response to what?
Parliament's response to the decision of the Supreme Court in Mercer. It's behind tab 41 at page 951. My Lord, and your Ladyship, the page 961, the Court will see that it's proposed to introduce provisions dealing with a detriment on grounds of industrial action. Work has a right not to be subjected to, as an individual, to detriment of a prescribed description by any act or any deliberate failure to act by the worker's employer, if the act or failure takes place for the sole or main purpose of preventing or deterring the worker from taking protected industrial action or penalising the worker for so doing. And this is the Secretary of State's response to Mercer. Now, what my learned friends will be urging on the court in due course, or at least what is contained in their skeletons, is that the blacklisting regulations should be permitted to include industrial action and should be, in essence, a parallel regime whereby those who are subjected to detriment on grounds of participation in industrial action should be able to obtain redress and in our submission that simply firstly isn't correct, isn't realistic, and in particular the position of the same Secretary of State who is the Minister in charge of this Act, but also represented today before the court, seems to be, as it were, ploughing an inconsistent political furrow in the form of the bill with the case which is being put forward on behalf of the Secretary of State today. But again, I'll leave that for further submission. The important element is this. What the claimant respondents are saying is that as a result of the blacklisting regulations, they are entitled to a remedy for participating in industrial, for detriment applied to them for participating in industrial action. However slight that detriment, and even if the industrial action is unlawful, provided it is official. And what the bill is proposing is that only detriments in respect of a prescribed description will be open to remedy, and only for taking protected industrial action.
I'm not understanding at the moment, Mr. Gott, what relevance a bill that may be before Parliament has got to do with the task which we are facing. I mean, of course, it's interesting when something's been up to the Supreme Court and there's a declaration of incompatibility to sort of, you know, see the denouement, which is that something's been done about that. But are you suggesting that this is of any relevance to the issues that we have to decide?
In respect of ground 2, which is the issue of if this court concludes that industrial action is included within the meaning of activities of trade unions within regulation 32A of the Blacklisting Regulations. The bill, and indeed further passages of Lady Simler's judgment when I come to it, in our submission, demonstrate that the only correct, realistic and logical conclusion is, like Judge Tobin at first instance, that the industrial action has to be protected. Industrial action. And indeed, it wasn't an issue in Mercer by the time that Mercer arrived in the Supreme Court. It was accepted that industrial action had to be lawful, protected industrial action. But the
So what?
well, it's our position that Mercer and Morais, having run parallel to one another, the findings in Mercer in respect of lawful industrial action are indicative of the correct answer to what industrial action should be protected under the Blacklisting Regulations, if any industrial action is to be protected at all. And in our submission, no industrial action should be protected under the Blacklisting Regulations.
Right. Well, like my lord, I'm puzzled as to why the wording of clause in the Employment Rights Bill should help us. It seems to me, for what it's worth, having been involved in the Mercer cases, that this is what the draftsman thinks will plug the gap identified in Mercer. They may be right, they may be wrong. We're clearly bound by Mercer. Anyway, you've shown us the clause in the bill. Thank you very much. Shall we go back to your ground 1?
My Lord, we submit that that our position on ground one is very straightforward. The Supreme Court interpreted activities of an independent trade union as not including industrial action.
Well, the Supreme Court interpreted activities of a trade union in Section 146 as meaning a particular thing. And you've shown us the passage which refers first to Drew and then to the significance of the words at an appropriate time.
My Lord, and the Court should likewise interpret activities of trade unions within the blacklisted, within Regulation 23A as not including industrial action, as not including participation in industrial action. The expressions are, in our submission, material identical. And the definitive interpretation of the expression activities of an independent trade union took just shy of 4 years from Manchester Employment Tribunal to the Supreme Court. The Supreme Court, in respect of Section 146, followed Drew. And it's noteworthy for the within Mercer that Drew was not challenged at any point. The Employment Tribunal followed Drew. That's Mercer in the EAT, page 587, paragraph 11, for your Lordship's note. The Employment Appeals Tribunal followed Drew in Mercer. Employment Appeals Tribunal followed Drew in Mercer. That's page 587 of the authorities, paragraphs 28-29. The Court of Appeal, on which your Lordship sat, followed Drew. And of course, the Supreme Court followed Drew. The language of the two provisions being Section 146, the activities of an independent trade union, and a Regulation 32A, activities of trade unions, are obviously, in our submission, patently the same. And so, as regards submissions on plain and ordinary language, we submit that those favour the appellant and not the respondent claimants. In any event, the linked statutory network, which we've been through this morning, supports my client's position. We make 3 basic points in this respect. Section 6.3 of the 1999 Act page 127 of Authority Bundle 1, expressions used in this section, in Section 3, and in the Trade Union and Labour Relations Consolidation Act 1992 have the same meaning in this section as in that act. And the expression activities of an independent trade union as not including participation in industrial action.
You're here, I'm just, for the help of our notes, you're tracking paragraph 42 of your skeleton argument.
No, I'm
Or are you somewhere else? But I think we have 3 points which are helpfully set out in with the text. So I'm sure it will be more accurate than
no.
the note I could take.
Yeah, yes, I am, my lord. Below, my lords, Judge Tobin gave the term trade union activities scant attention and analysis. And His Honour Judge Auerbach, approaching the issue of the meaning of trade union activities in his judgment, paragraph 91, for your lordship's note, considered that Drew and Mercer in the EAT supported an interpretation of activities of trade unions which included participation in industrial action. But that, in our submission, is wrong. Drew and Mercer, Drew is the domestic interpretation, and Mercer in the EAT upheld Drew as the domestic interpretation. And secondly, where an act, our second point, where an act is the Section 11 of the Interpretation Act 1978, where an act confers a power to make subordinate legislation, expressions used in that legislation have, unless the contrary intention appears, the meaning which they bear in the act. It's not, my lords, the blacklisting regulations to which reference have to be made when interpreting the expression activities of trade unions, but the expression activities of trade unions in Section 3 of the 1999 Act, pursuant to which the regulations were enacted. The 1999 Act, in turn, in our submission, by dint of Section 3, subsection 6, takes us back to the 1992 Act and the Supreme Court's analysis and definition in Mercer of the term activities of an independent trade union. The third...
Well, you've set this out very clearly in your skeleton argument. 45, 46, 47.
Well, my lord, for the purposes of Drew, my lord, and thence Mercer in the Supreme Court, it was the existence of the sibling provisions, as Lady Simler called them, of Section 146 and Section 152 which were determinative of the issue and the conflict this generated between section 152 and the provisions in section 237, 238A, if section 146 was to be interpreted as including participation in industrial action. The claimants, in respect, claimant respondents, assert that this court, like the Employment Appeals Tribunal below, should interpret the words in Regulation 32A, activities of trade unions, using ordinary language. My Lord, that is not, in our submission, a satisfactory approach. It was not a satisfactory approach for the Supreme Court in Mercer, and with respect submitted that it would be incorrect for this court to adopt the same approach. Very similar in Mercer, acknowledged that as a matter of ordinary language, activities of an independent trade union were capable of including participation in industrial action, but they could not do so as a result of the decision in Drew, which she directly upheld. Now, as I've already submitted, exactly the same issue would arise in this case if this court interpreted activities of trade unions as including participation in industrial action as a result of section 104F, which was introduced, as I took your lordship to, by regulation 12.2 of the Blacklisting Regulations. The activities of trade unions should be interpreted the claimants further submit that activities of trade unions should be interpreted as including participation in industrial action, as otherwise those participating in industrial action may be placed on a blacklist. That, in our submission, is a circular and bootstraps argument. It's no answer to the application of simple rules of statutory interpretation, which we ask this court to apply, set against the damage to the regime in section 237 to 238A of the 1992 Act, which would arise from section 104F, which is the sibling equivalent of regulation 32A of the Blacklisting Regulations.
could you help on this broad point, which I'd certainly welcome the responses of other parties in due course. Bearing in mind the protection from detriment that appears in 146, what distinct purpose are blacklisting regulations there for?
Well, my lord, they were introduced primarily as a result of the scandal of the Consulting Association. Of the Consulting Association. Consulting Association was an organisation which was working with mainly the construction industry and kept a card, a non-electronic large card index of trade union members who were then excluded from employment within the construction industry as being potential troublemakers. And that is blacklisting as it's classically understood. Blacklisting it's a matter of, it is seldom something which takes place as between employer and employee. It takes place normally as between prospective employer and prospective employee.
It appears to have been argued before the Employment Tribunal in this case that there was, as it were, a sole use defence, that if all that Ryanair were doing was to keep a record for internal purposes of those who'd taken part in industrial action, that would mean the regulations didn't apply. Tribunal rejected that, and it doesn't seem to have been appealed. Is that correct?
No, that element, my lord, yes, that was argued, the literal meaning of employers, but the tribunal found against us, and on the basis of the Interpretation Act, that the plural contains the singular, and we came to the conclusion that that point, at least, would not be appealed further.
No, right, good. Now, you've been addressing us on what is obviously a central point in the case. Is there anything further to say? You, in your skeleton argument, you go on to say why no attention should be paid to the documents which were issued by the department when the blacklisting regulations were before Parliament or were about to come into force. You haven't dealt with that. Is there anything else under Ground 1 that you haven't covered?
I'll come to those documents and I'll try and take them as quickly as possible. There is this issue. It's said by the claimants that firstly, that the 1992 Act does not contain a definition of activities of trade unions. Consequently, we are not allowed, or not permitted, or not able to rely on Section 3(6) of the Act in order to bring in the expression from the 1992 Act. In our submission, post Mercer, the Supreme Court the Supreme Court has given the clearest definition of excluding participation in industrial action and confirming the long-standing position in Drew. The claimants claim that Section 170, sub 2 of the 1992 Act excludes participation in industrial action in respect of time off to participate in trade union activities. This Section 170, subsection 2, was repeatedly raised at each tribunal and court in Mercer's passage to the Supreme Court and comprehensively ignored on each occasion. For your Lordship's note, it was paragraph 15 of Chowdhury P's judgment, which is found at
Sorry, speaking for myself only, this is very hard to follow. This is not in your skeleton argument at all, is it?
No, it's a response to a point which is made in my learned friend's skeleton argument. Perhaps, my lord, I should take the court to Section 170, sub 2.
We'll need to rise for the short adjournment by 5 to 1. That's any help. Right. Section 170.
Section 170 sub 1 provides for an employee.
And the page?
I'm sorry, my lady. Page 40.
Thank you.
170 sub 1 provides for time off for trade union activities, but sub 2 says the right conferred by subsection 1 does not extend to activities which themselves consist of industrial action, whether or not in contemplation or furtherance of a trade dispute. Now, this was deployed in Mercer page 583 of the authority bundle.
Deployed before the EAT.
Well, my lord, it was clearly deployed before the ET as well, because at page 589, Chowdhury President says, I cannot improve upon the Tribunal's excellent summary of the relevant provisions of TULRCA, ECHR and Human Rights Act. At paragraphs 27 to 46 of the judgment, I set out in full, and then overleaf, cribbed from the Employment Tribunal, at the top of page 590, is section 190, sub 1 and 2. So, deployed in front of the tribunal and in front of the Employment Tribunal. But both the Employment Tribunal and the Employment Appeal Tribunal came to the conclusion for a domestic interpretation that they would follow Drew. For the purposes of the Court of Appeal, my Lord, if we go to page 692, and go to paragraph 7 of the judgment of my Lord Burnett, page 697, part 3, paragraph 7, part 3 contains provisions dealing with time off for trade union duties and activities, section 107. But then, as in the Employment Appeal Tribunal, the section 170 sub 2 never surfaces again in the Court of Appeal. It's taken into consideration and ignored. And finally, my Lord, page 717, paragraph 14, the judgment of Lady Simler, 725, paragraph 14, section 170 provides forest material, sub 1, sub 2. And so it was before the Employment Tribunal, the Employment Appeal Tribunal, the Court of Appeal and the Supreme Court, none of whom analysed it substantively, all of whom ignored it, all of whom, my Lord, followed Drew.
Right, thank you. We'll break off now. We're still on ground 1. There's grounds 2 and 3 and the respondent's notice to go. I don't know whether you had discussions between you, but it seems to us that you and Miss Claimants ought to be in a position to pass on the baton by about 3 o'clock. So if you could adjust the tempo to accommodate that, that would be very helpful. Right, we'll return at 2:05.